SJC-12709, Commonwealth v. James L. Adams.
Katz, good afternoon. I'm sorry, Mr., you're not Mr. Katz? Yes, you are Mr.
Yes,
Katz.
no, I,
Mr. Adams. Sir, Mr. Adams.
sure. Good afternoon, may it please the court. Scott Katz on behalf of James Adams. We raised two similar but distinct double jeopardy claims. The first seeks dismissal of the 4 rape counts on which Adams was convicted, while the second seeks the lesser remedy of a new trial on those charges. I want to start by addressing the waiver issue on our first claim, the dismissal claim, and why the appeals court's decision in Commonwealth v. Spear should be overruled. According to Spear, even if everyone now agreed that Adams' double jeopardy rights had been violated, he would have no remedy.
And that doesn't feel fair.
I agree, Your Honor.
So my question is, where does this theory come from in the law that double jeopardy has to be raised before a retrial? What was the reason for it?
I mean, I think if you look at Spear, Spear is relying on the Mass Rule of Criminal Procedure that says pretrial motions need to be brought, and it's relying on Chapter 277, Section 47A, which deals with, which I would say doesn't even really apply here, because it deals with defects in the grand jury proceedings or in the indictment itself. But the real
Or technical kinds of problems?
Correct. I mean, the real problem with Spear is, Spear, which came before Randolph, is essentially, Spear says, okay, there's a waiver here. And then they stop there, and they say, what does waiver mean? Waiver means we don't consider the claim. And
But isn't the danger being set, as counsel just said in the last case, right? Isn't the danger being set to the bar a second time? And if you don't raise the issue, you have been set to the bar a second time.
I mean, on behalf of Mr. Adams, who's now in prison, I would say that it's not just being set to the bar a second time.
But that's why you raise double jeopardy. You say to the trial judge, dismiss the case because the evidence wasn't sufficient in the first trial, correct? And then we give you a right to appeal.
Sure.
And then, but when you don't raise that, you go to trial again.
Well, I mean, let's start from the fact that the default rule for all claims, for any type of claim, is that when the claim is waived, as we agree that the claim is here, it gets reviewed for substantial risk of miscarriage of justice. That's the default rule for any claim, an evidentiary claim, a jury instruction claim, anything. And so the question is, are we going to carve out an exception for double jeopardy claims? And what I would say is, given the nature of double jeopardy claims, and this is essentially what this court recognized in Negron and in Dykens, given the nature of double jeopardy claims that literally go to the power of the court, the power of the state to bring the defendant into court, if anything, there's even more of a reason for those claims to get reviewed than most other types of claims that all get substantial risk review.
Can I ask you how this works? So if we agree with you and we say under Randolph, you're right, there's a substantial risk for all claims, waived or not, then the inquiry on appeal, he being convicted, was whether or not there was sufficient evidence in the first trial to go forward on a second trial?
Well, that's not the claim we make here. We're not arguing
But
that
I'm asking you how it would work, though, if we agree with you.
in that kind of a claim as opposed to the kind of claim that we raise. Yeah, I think
Well,
yes.
so-
I mean, the court has said.
But what's puzzling is, right, so now you have to look for double jeopardy purposes as to the evidence in the first case, correct?
Yes.
Whether it was sufficient. And then in the second trial, if there was a waiver, you could have different evidence. You could have a new witness come up.
Again, I want to emphasize that we don't raise a sufficiency claim in this case. That's a different kind of double jeopardy claim than we're raising. But I would say the result should be the same way that if a sufficiency challenge isn't raised at trial and then someone comes up on appeal, what this court has said is anytime the evidence is insufficient, it is necessarily a miscarriage of justice.
Right, that's the typical claim. I know in your case, you have the issue of whether he was acquitted or not.
Correct.
On the joint ventures, but that's what we usually see on double jeopardy. that's more the
Yeah, I
issue.
think that's
So I'm
right.
just
I mean-
wondering, what's the ramifications of going your way? That's what I'm trying to get you to address.
I mean, the way that it would come up again is it would have to have been that, it wouldn't be if a defendant was convicted, obviously, and it wouldn't be if a defendant, because then they would have a direct appeal. It wouldn't be if a defendant was acquitted, obviously, that'd be the end of the case. It would be in the rare circumstance where there was a hung jury, and then prior to the retrial,
Okay, there's a hung jury.
and then prior to the retrial, defendant
Does not,
does not move to dismiss, saying that the evidence of the first trial was
right,
insufficient.
goes to trial, is
Correct.
convicted. Then you say on appeal, the court should look at the first trial to see whether or not the evidence was sufficient on a substantial risk analysis.
I'm saying that if the defendant fails to do that and then raises it later, I think that's fine to do. And let me give a couple of reasons. One is that really serves the purpose of double jeopardy. I mean, the point of double jeopardy is, or one of the points of double jeopardy is, the government doesn't get a chance to sort of hone its case. So just because the government at a second trial may introduce all this evidence, and that's one of the things that we argue the government did in this case, just because the government realizes, oh, the first time around we didn't really do a good job, so we're going to strengthen our case the second time around. Part of the double jeopardy is to prevent the government from doing that. So if it's because the government's getting that second chance because of a hung jury in the first trial, and they realize, actually, even though the defendant's not raising the issue, our evidence was actually insufficient, we're going to introduce all this new evidence. That's one of the dangers that double jeopardy guards against. The other thing I would say is, in that case, if the point is that at the first trial the evidence was insufficient, and then before the second trial counsel is not even raising the issue, it's going to be a very clear case of ineffective assistance. And this is one of the things that Randolph raises, is that a claim that's not raised can almost always be recast as ineffective assistance, and you're going to wind up in the same place anyway. So for all those reasons, I don't think there's anything the least bit controversial about saying double jeopardy claims, which literally go to the power of the state to bring defendant into court, should not be an exception to the general rule.
Ask you then, why should we, if we followed that line of thinking, if there were an appeal after a first trial, normally we don't address double jeopardy claims in that first appeal. We say that waits till the Commonwealth tries to try them again, and you raise it in the motion below. Shouldn't, under your scenario, wouldn't we be obligated to start thinking about that ahead of time?
I confess it's not something I've thought about. I don't think that the court would need to go there, simply because it may never become an issue. If the defendant's not raising it then, and he or she may not raise it later, it may never become an issue. I don't think the
Commonwealth
court...
may not prosecute.
Exactly. There's a whole host of reasons. The other point that I'd like to make about this is, in large sense, in addition to Randolph being decided after Speer, in some sense, the court has already decided this issue in Gronin and Dykens. In both of those cases, the court reviewed double jeopardy claims brought in cases where the defendants had pleaded guilty. They agreed that they had committed multiple offenses, and then later filed motions for new trial saying, actually, being punished twice for the same crime. And even in those cases where no motion to dismiss was filed, the court said, because of the unique nature of double jeopardy claims, we're going to review those.
And also, isn't there a issue under the United States Constitution? Isn't there an argument that Spears and that level of protection is inadequate, and that the cases that you cited in the circuits, I think maybe the Eighth Circuit being one, where at least the double jeopardy issue, if it's not raised and you're looking at it afterwards, at least is a plain error analysis.
That's right. I mean, obviously the federal courts treat waiver issues differently than we do here. They sort of distinguish between forfeiture and waiver. And a forfeiture is what we would normally call waiver, where you don't raise a claim. And on a forfeiture claim, yes, they would still review it for plain error. And it's not just the Eighth Circuit. The Eighth Circuit, I cited that case in my brief. They actually cited, I think it was, I don't remember how many of the other circuits, but essentially the federal courts are essentially unanimous on the issue that if you just don't raise it, it's still going to get reviewed for plain error, which I would analogized to substantial risk.
So let's assume for the moment that we reach it. Why does the acquittal on a joint venture alleging an oral rape mean that the jury effectively found no joint venture when they were hung as to the vaginal and anal rapes?
First of all, the fact that they're hung is not something that we can consider. It's as if those charges don't exist.
Well,
It's
that
as if-
doesn't make sense, though. I mean, in real, I mean, I know what the language you're quoting, but it did happen. And so why, it's a continuing jeopardy. So we have to acknowledge this, don't we?
I acknowledge it in that sense that it is a continuing jeopardy and that, those charges are still there. But it's really more like successive prosecutions in the sense that the way that we need to look at it is as if those charges were not brought in the first case and then
As
the
if there was
government
never a trial.
re-indicted. I'm sorry?
As if there was never a trial on those?
As if there was never a trial on those and then the government said, we're going to bring new indictments for the vaginal and anal rapes. That's what Yeager tells us, is that essentially when a jury is hung, they've said nothing. We do not consider it. Even if it's entirely inconsistent with the acquittal, we don't consider it at all. It's a complete non-factor.
So let's go back to the question. A jury finds somebody not guilty of an alleged joint venture involving an oral rape. We all know that there could be a difference in terms of the quality of proof as to whether or not there was penetration for an oral rape versus a vaginal or anal rape. Why should the fact that the jury here found him not guilty of joint venture with regard to the oral rape mean that they effectively found him not guilty of joint venture with regard to the vaginal and anal rapes?
I mean, I think you've got to look at what the evidence in the case was, how the case was tried, and what the jury actually did say in their verdicts. So if we look at the evidence, the Commonwealth presenting evidence from the victim that she was orally raped by 2 people. Adams, in his statement to the police, corroborates that. This fact is essentially undisputed. The only way for the jury to acquit on these charges is either to determine that the co-defendants Brown and Spencer did not orally rape the victim, or that Adams was not a joint venturer. And it's essentially undisputed at trial that Brown and Spencer did orally rape the victim. The defendant, during his closing, told the jury not to convict Adams because, quote, well, his friends were having sex with her, even though they thought she was 19, it was consensual. Adams, was busy stealing her iPod. He early talked about the third man standing by, well, referring to Adams, while the other 2 are having sex with the victim. And
Okay, how about the forensic evidence? Was there forensic evidence with regard to sperm in the vagina and in the anus that was different from what was found orally?
The evidence was different as to sperm in the vagina, yes.
Okay, so I mean, it's not uncommon for a jury to look at the forensic evidence and say, well, we're not so sure that the testimony is reliable as to the oral rape, and there's no forensic evidence of it, but we have forensic evidence to corroborate the testimony concerning the vaginal rape, and therefore we view those differently.
I mean, I think in many cases that I can see the appeal in that. The issue in this case is that the defendant wasn't pushing that defense. The defendant, as the Commonwealth itself told the jury during the closing, what the defendant is contesting here is that he shared his co-defendant's intent and that he committed those acts himself. I mean, there was sort of one throwaway line in the defendant's closing where defense counsel did make a reference to, essentially what Your Honor is alluding to, that, there's not DNA evidence for defendant Brown. But essentially, if you look at this case, if you read this case from, read the trial transcript from beginning to end of the first trial, the case was tried, literally the basis of the case was Brown and Spencer had sex with the victim while Adams merely stood by. That was the defense. So it's entirely unrealistic to say when the jury accepts that defense by acquitting him on the joint venture charges that they may have been saying to themselves, well, actually the reason that we're going to quit is not for any reason that the defendant is pushing, but instead because even though the defendant himself in his statement to the police said that all this was going on, we don't believe the victim, we don't believe the defendant either. It's just not, the Supreme Court tells us we need to look at this practically and realistically, not as a matter of hyper-technicality. And I think when you look at it in that vein, the only place you can wind up is that the jury, the jury is acquitting him of being a joint venture. What makes this case difficult, and this gets to Justice Seifer's question, what makes this difficult is it's very difficult to put out of your mind the fact that the jury did hang on those other charges. And so, your mind wants to tell you, well, if they acquitted on the oral rape, they should have acquitted on the other ones too. And it's almost like, password or the $25,000 pyramid. You've got to buzz yourself anytime you think about those other charges, because Yeager tells us that they are a non-factor and they cannot be considered.
Thank you. I think your time is up. So
Can I say a few words about our second claim? Because in some respects, I do think it's a stronger claim in the sense that it's more straightforward what the jury decided on the second claim.
the second claim being?
The second claim being that the jury at the first trial clearly acquitted Adams of personally committing any of these rapes. And then at the first trial. And then at the second trial, the government was permitted to introduce evidence and argue to the jury that he did have intercourse with the victim.
Okay, I'll give you 2 minutes.
Thank you, Your Honor. And I say second claim is both more straightforward for that reason. It's also a little bit more complicated because the Commonwealth's position has changed during the course of the case. And I go through the details of this at pages 15 through 17 of the reply brief. But basically, the position the Commonwealth now takes on appeal is we agree with the defendant. It was how I read the brief is they agree with the defendant that they should not have been permitted to introduce evidence that Adams personally raped Ann at the second trial. And my response to that is, if that's really your position, why didn't the Commonwealth just assent to the defendant's motion in limine to keep all that evidence out? Instead, what the government argued below was that they should be permitted to introduce evidence that Adams was, quote, actively involved by committing the rape himself, that they were entitled to introduce evidence that tended to show he had sexual contact with the victim, and that to the extent the evidence shows or proves or implies that this defendant physically sexually assaulted her, in addition to the other ways he participated, I don't see a basis for excluding that. And so what the government is essentially saying is, we fought to introduce evidence. We opposed the defendant's motion in limine, and we fought to introduce evidence that, in fact, that Adams had intercourse with the victim. And now they get up in appeal and says, well, even though we fought for that, actually we didn't introduce any evidence of that, and we didn't argue that to the jury. And I have a number of instances in the brief where I think it's very clear that that's what they did. They're arguing repeatedly that at least two of the 3 men had personally raped the victim. They shouldn't be allowed to argue that if Adams has been foreclosed as having personally raped her.
All right, okay, thank you.
Thank you, Your Honor.
Ms. Simony.
Good afternoon. Kate Simony, Assistant District Attorney, appearing on behalf of the Commonwealth. I was the prosecutor at the second trial. If I may just briefly respond to the last argument made by counsel, I think it's important to have some information about the chronology of the events in this case, and especially in regards to the question of why the Commonwealth did not assent to the defendant's motion. Although it's now being framed as if it was a motion to preclude introduction of evidence that the defendant forcibly or personally raped the victim, what the actual motion, which is included in the record appendix, sought to exclude was both much broader and much less clearly defined. What it actually sought to exclude was all evidence tending to show all evidence relating to the issue of whether the defendant had any manner of sexual conduct with the victim, which in the motion and in the argument, counsel explained he thought basically precluded all evidence except the defendant's distribution of condoms. So the argument that was had should be understood in that context, that the argument that also while the defendant's motion sought to exclude a broad and not clearly defined amount of evidence, it was important to know that the actual evidence in the case, which included a lack of direct evidence that the defendant was guilty of personally or physically raping the victim, was before the parties. The transcripts of the prior trial were in the possession of both parties and the judge, as is evidenced in the transcript. And so when there's discussion of overlap of evidence and all the evidence of the defendant's conduct, it was not relating to evidence or direct evidence that the defendant personally or physically raped the victim herself as a principal, as opposed to evidence that may tend to imply or infer that he had some other or some sexual contact with her during the course of events. So the question was not whether there was an overlap in proof, but there was no evidence, testimonial or otherwise, submitted during the trial that the defendant physically or personally committed the acts of which he was acquitted in the first trial.
Okay, may I ask you, why can't a defendant raise a double jeopardy claim at any point?
Well, and I think there is,
And for this?
I think obviously there is some tension in the case law. I think that the reasons that have been explained are those related to the finality of judgments and judicial efficiency, which includes not only with respect to the court system, but subjecting both defendants, victims of crime, and other witnesses through the trial and expense of the trial process.
Right, but this, I mean, there are many exceptions we make for many different kinds of claims. Why doesn't this merit an exception?
And I think that that this is distinct in that it's an issue that can be resolved entirely without placing the defendant at the bar for trial. And the process and the procedures that are set forth to do that are the best way to handle these issues prior to going through the entire process of a further trial.
But isn't Spear sort of a vestige of the pre-Randolph world we were in, where we had all these complicated waiver analysis, and Randolph kind of simplified this? Do we really want people retried when there's not sufficient evidence? And isn't the substantial risk approach adequate here?
Well, I think that the issue before the court with respect to this case is whether in this case there was actually error. And in this case, there was no error, let alone a substantial risk. So I think in this case, we don't reach the question of whether that is the appropriate standard. I think here, what counsel's argument with respect to the jury's determination in the earlier case, that what that misapprehends is that whether someone is a joint venturer is not something that's decided in an all or nothing manner. That the jury is presumed to follow the instructions of the judge, and the judge properly instructed the jury that each count should be considered and decided individually. That the defendant should be considered, it should be considered whether the defendant was a joint venturer with respect to each claim or each charge that was before them. And here, there is, the jury could have rationally grounded its verdict on several different issues. And as Your Honor has recognized, there's both differences in the proof with respect to the oral rapes and the anal rapes and vaginal rapes. So I think there's also the overarching issue that I think a fair reading of the evidence in the first trial is that there is not whether there were 3 men that were involved in the assault generally, but the question that was before the court that was raised in closings was which defendant was responsible for which specific act that was charged. When defendant cites the elements of the charges that were before the jury in the first trial, it leaves out that the jury was specifically provided with the verdict slips, and they were specifically told which specific acts by which specific defendants applied to each charge. So they not only had to find that the victim was orally raped and anally raped and vaginally raped, but that it was done specifically by each defendant. So they had to determine in a way that the victim was unable to do in her testimony at trial which defendant committed which, if any, acts. So I think that the jury could have decided that it couldn't determine beyond a reasonable doubt which defendant committed which acts. And with respect to the oral rapes, there was not only differences in the proof relating to which defendants committed the acts. There were the medical findings, which provided additional corroboration for the anal and vaginal rapes. There was the DNA evidence, again, providing additional corroboration for the vaginal rapes. And there was additional detail in the defendant's statement, which was through the testimony of the detectives, as to the acts that the defendant claimed were committed by the two co-defendants.
On that
So-
last point, when you mention that, going back to your first issue, the DNA, the sperm in the back of the underwear and on the shirt of the defendants, how does that relate to the defendant's argument that at the second trial, you were arguing that the defendant actually participated as a principal in the rape?
Well, I think that the DNA evidence it was the DNA that was found on the victim's bra that belonged to the defendant was amylase.
No, I know that. I'm saying at the second trial, there was the underwear, sperm in the underwear, and I think on the shirt.
That was identified, the major profile being one of the co-defendants.
I think of the defendant.
The defendant was a minor profile in the sperm
Yeah,
fraction
but
of
the math
abortion.
was overwhelming.
Yes. So I think that all of the DNA evidence in this case, none of it directly inculpated the defendant with respect to actively committing the rapes, that it was evidence of his participation as a joint venturer, that he was actively involved.
Even though the sperm's on the underwear and on the shirt?
I don't believe his sperm was on the shirt. I think it was saliva that was on the
He
tank
admitted
top.
to some type of sexual conduct during the episode
That he was...
that he participated in.
Well, we know that he was engaged in sexual conduct during the episode,
Right.
because by his own statement, he was there.
That's what I was referring to. So,
Yes.
So by precluding the defendant, so that's why his motion to eliminate was overly broad.
Yes. Yes, and so the fact that he was involved and participating, and whatever that participation was, whether it was by touching the victim, was it by helping move her, was it helping remove her clothes or help her put her clothes back on, whatever it was, it went to his participation in the joint venture. None of it was directly inculpatory of him having committed the acts of oral, anal, or vaginal rape. So, and with respect to the oral rapes and the differences in the proof between the oral rapes and the anal and vaginal rapes, one of the most important issues, or the most important points, is that there was additional proof of the defendant's participation as a joint venturer in the first trial with respect to the anal and vaginal rapes. This was something that was discussed by both parties in closing, and it was emphasized by both the prosecution and the defense. The defendant admitted bringing and supplying the condoms for both himself and the co-defendants, and the victim's testimony was clear that the condoms were not used during the oral rapes. So to the extent the jury's verdict carefully considered whether he was a joint venturer with respect to each specific charge, that could clearly be a factor that was considered with respect to the oral rapes versus the anal and vaginal rapes.
Okay.
Thank you.